Good evening. Welcome to Illinois Law, brought to you by the Illinois State Bar Association. My name is Nancy Hablitzel, and I'm your moderator this evening. I have with me three guests who are going to talk about student discipline in the schools. And we're talking about just the regular standard methods of disciplining students and controlling behavior, I guess. My three guests are first Mary Klemish, who's a partner at Safe House Shaw in Chicago. She's a member of the Executive Council of the Illinois Council of School Attorneys and has been representing public school districts for approximately 20 years. Her practice focuses on public sector and education law, including the breadth of issues raised by Titles I and II of the Americans with Disabilities Act, Section 504 of the Rehabilitation Act, as well as the Individuals with Disabilities Education Improvement Act. And my second panelist is John Dively. John is a professor and chair of the Educational Leadership Department at Eastern Illinois University. He teaches courses in educational research, school community relations, and school law. He has been a practicing attorney, a school administrator, and the executive director of a statewide principals organization. My third panelist is Deb Decker. Deb is a partner at the complex commercial litigation firm of Tabbitt, DeVito, and Rothstein LLC in Chicago, where she handles a wide variety of commercial litigation matters at both the trial and appellate levels. She also represents parents and children on issues involving school law and is on the board of directors for the nonprofit association Autism Alert. Deb is a member of the Illinois State Bar Association's Education Law Section Council and serves as its secretary this year. Welcome to all of you. I'm glad to have you with me. You've been on this show before, and it's always been very informative. We're talking tonight about regular school student discipline of all the children in the school. And let me ask, first of all, just as a general matter, where can the school discipline children? What issues are available for disciplinary intervention? John, you want to start that one?
Sure. Of course we know that we can discipline students. The students are under our jurisdiction, under the jurisdiction of the schools, when they are at school or at school-related activities. That may include away basketball games or field trips, any sort of school-sponsored activity. The school has control. Now, in addition, there are some circumstances under which the school can discipline students for off-campus behavior. Those are a little bit more fact-driven, and we can talk about that a little bit more.
And Mary, where would a parent go to find out what are the disciplinary guidelines for any particular school?
Most schools have student handbooks which provide and outlines the student discipline policy of that particular school. And it typically will identify that inappropriate conduct is not to be tolerated at school at any time, and it will include a statement that any behavior which is inappropriate will be responded to, and it will also typically define severe misconduct that might warrant a suspension from school or expulsion from school, and identify the specific kinds of conduct which would warrant that kind of more severe punishment into a disciplinary act or an act of misconduct.
Would a parent who was looking at a handbook then be able to just figure out what kinds of issues are considered disciplinary infractions?
Yes, the student handbooks and the school code regarding discipline is designed so that parents and students can understand it.
And so the student could actually read the discipline code too.
Yes, and in fact,
should.
It's a good idea as a parent to go over the discipline code with your student. Now, some younger children may need some more help with the code. Older kids are going to be able to pick it up on their own.
Mm-hmm. And would this list things that may be brought into school, may not be brought into school, as well as activities?
It doesn't have to be as specific as obviously a criminal code, and the courts have been very clear on that, but it does have to provide a general notice to students about what is permitted and what is not permitted in the school. On the one hand, of course, the handbook, which has to be updated annually by the Student Teacher Parent Handbook Committee and has to be distributed to students at the beginning of every year. or within 15 days of enrollment. The handbook deals with a whole variety of issues. So not only in terms of just pedagogically making sure everybody understands what the rules are, but also from a legal standpoint, it also provides notice of the rules of the school, which of course is the first element of due process.
Mm-hmm. So if you have a student who hasn't come home with a handbook, should you go to the school and get one?
You could go to the school and get one, or likely the discipline policy would also be online. Most school districts, public school districts, have a website, and the code of conduct might easily be accessible on the website as well.
And of course, if you've lost the handbook, that would be a good place to check.
Good place to start, yes.
Okay. Given that you have the handbook then and the student infractions are listed, or the guidelines or whatever, what would the procedure be if a child violates something in the school handbook?
Generally, it depends on what the violation was. There are some things that are going to be very serious and that you can have severe implications just on one time. Bringing a gun to school, bringing drugs to school, school violence. Those types of things may even be handled with a zero tolerance policy, which means one time, it happens one time and the consequences of that are severe. Other things are going to be dealt with in a different fashion. It depends on how serious the offense is.
And is there some leeway in most discipline codes based on the age of the child?
Mm-hmm. Yes, there's a lot of factors that an administrator would take into account on determining what would be the appropriate disciplinary consequence for the student. And age certainly would be one of those things that you would want to consider. Other things that you'd consider would be, the past track record of the student. If this is a first-time offense, you'd also want to consider, what kind of impact it's had on the school. Those would be some of the things that, that you would want to take into consideration to make sure you make the punishment fit the crime.
If it's a crime.
Right,
yes.
right.
Yes, but certainly the violation.
That's right.
And then when a child is disciplined, how is a parent typically notified that your child is in need of discipline for whatever reason?
That might vary from one school to the next, but typically if it's a reprimand of a child in the classroom because a child didn't bring their papers and pencils or homework, the parent may not necessarily be informed that there was some kind of disciplinary response, so to speak, for that kind of misconduct. But if there is more serious measures being considered or contemplated, the parent will typically get a phone call, and then it would be followed up with written communication providing notice of the misconduct, and potentially, if it's suspension or a recommendation for expulsion, potentially be called in for a meeting with the administration and their child, and an opportunity for a hearing. And if there is expulsion, then there would be a hearing or a meeting with the district's Board of Education or a hearing officer appointed by the board.
And that leads us right into the next thing. What are maybe the options in a suspension? John, what kinds of suspensions or suspension options could a school district use?
Well, and schools have tried to become very creative in dealing with this, because external suspensions where the student is told, you need to stay home for the next 3 days, we know has pedagogical ramifications. The student is not in class, and therefore they're going to miss out on what's going on there. So in some cases, we become creative. Maybe we go with some after-school detentions, or we go to a Saturday school suspension where they're required to come in over on a Saturday on their own time, and that tends to be a pretty good deterrent. Or maybe they have lunch detentions, or they have to come in early in the morning. There are a number of different possibilities there, and those are generally tailored to the school, the community, and what's effective.
And can there ever be a situation where there might be several options and tailored to this particular student? Right.
You may have a student who lives several miles outside of town, and so that they may not be able to stay after school, or getting to a Saturday school suspension may be difficult. So, right. administrators are going to not only legally but also pedagogically, we want to work with those students and make sure that you know, we meet them where they are.
And again, when you're doing this kind of a suspension, what are the procedures that the school has to follow?
Well, if you're going to suspend a student, you would call them in, and at the very minimum, the due process required is you ask them what their side of the story. First of all, you would tell them, look, this is what has been, this is what they said you did, and what's your side of the story, and then they would have an opportunity to respond to that. If they may ask you to talk to some other people who were there. They'd have an opportunity to present some evidence to you. At that point, the administrator could make a decision on the suspension. If the parent then wanted to, and as Mary has pointed out, we would send notice to the parent, we'd call them, we'd also send them a letter outlining what the offense was, what provision of the handbook they violated, how long they're going to be out, when they can come back, and that they do have a right to appeal or to have a hearing on the suspension. And so if the parent elects to do that, then they would come in and meet with the administrator that had rendered the disciplinary, and then would move up through the administrative ranks until, as we mentioned, they could ask for a hearing before the board. Or that might be, in some school districts, that's before a hearing officer. And then, so now with an expulsion, as Mary pointed out, the hearing officer's decision would have to go to the Board of Education because only the board can expel. But in a suspension, it's the dean of students, the assistant principal, the principal, or the superintendent can actually do the suspension.
And when they look in this handbook, will it usually tell the kinds of offenses that you might consider a suspension for?
It generally describes serious misconduct that warrants either a suspension or an expulsion, and there's discretion left to the administrators to kind of use their discretion in determining the difference between the two. I also want to point out what the difference is between a suspension and an expulsion in Illinois. A suspension is generally considered a removal from school or a change in a school's placement of a child for 10 days or less, 10 consecutive school days or less. An expulsion is the removal of the student from school for any more than 10 consecutive school days. So an expulsion could be for 11 consecutive school days, technically under the laws in the state of Illinois. But it's a longer removal of the student from the student's opportunity to be educated in that regular school setting.
And I'm going to ask you in a few minutes some questions about not just the differences, but how they operate and how we look at that. We're going to take a short break, and we'll be back in just a minute. I'll be back talking more about school discipline in Illinois and discussing a little bit more about the procedures perhaps for a child who is going to be either suspended or expelled. And we'll be back in just a few minutes with my three panelists on Illinois law.
Bye-bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault! Never!
Over and over.
Come on! It's our problem! Leave me alone! Shut up! Out!
Time and again.
No! Drive me nuts! Shut up! You're the dumbest...
Generation after generation.
I hate you! I hate you too!
Isn't it time you stop the cycle? Now.
I hate you! I hate you!
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to Illinois Law. I'm Nancy Hablitzel, and I'm your moderator this evening. I'm here with three panelists, Mary Klemish from Safe Our Shaw in Chicago, John Dively from Eastern Illinois University, and Deb Decker from Tabit, DeVito, and Rothstein in Chicago. And we're talking about school discipline issues. Just before we took our break, we were talking about suspensions. And I wanted to ask a couple questions about the various ways in which suspension procedures happen, the various types of suspensions, perhaps. And then in addition to that, I'd like to know some of the other maybe codes of behaviors, academic and non-academic activities that might bring children into a different level of intervention from the school. So, Mary, you start.
Well, first of all, with respect to suspensions, typically if there's an out-of-school suspension for 10 consecutive school days or less, the parent will get a notice that there has been a suspension and when that suspension will, for how long that suspension will be in effect. And the parent typically may have been called by the dean of students or an administrator to say, your child is engaged in this misconduct. We had a meeting with your child and this is what transpired, and we are going to suspend your child until X date. And the parent will get a follow-up to that in writing with, again, an explanation of the conduct and an invitation to appeal that decision if they would like. But it's not going to stop the suspension from occurring. The student will be removed from school for that number of days, and that there may be an opportunity to revisit it, but the student will be out of school. And so that's typically what you would see for an out-of-school suspension in terms of the procedures.
Are students ever allowed to make up the work that they miss on an out-of-school suspension? Or is that automatically zeros?
You know, that's an unsettled area of the law in Illinois right now is can you discipline someone academically for behavioral issues? And some of the advice that I would give is that the answer probably is no. There's really not a rational relationship between a fight in the library and getting a 0 on your algebra. So some schools have gone to more of a hybrid type of policy where a student can get partial credit for unexcused absence. An unexcused absence, of course, would be when they were out on suspension or if they were truant. So there have been some, but there are still schools out there that do give zeros, and there are others that allow students to make up all of their missed work with 100%, and then there's some in the middle.
Okay, so we have kind of a hybrid and still.
We do, yes. We really don't, we've got a couple of cases out there, but it's conflicting right now. We don't have anything on, right on the mark that tells us that you can't discipline someone. You couldn't give a student a 0 for a day that they were out on suspension. We don't have that.
What are some of the out-of-school activities for which a child can be disciplined?
I think a big one is if it's a school-sponsored event. And sometimes it's not just the handbook, but it's also a code of conduct that might be violated, that might result in a violation for which there could be discipline.
Would this be something, a code of conduct, say for band members or football players or any other activity?
Right. There is, in addition to the code of conduct that all of our students are expected to comply with in the school setting, there may be additional codes of conduct or expectations for students who participate in extracurricular activities. Whether they're in the band, on the basketball team, a cheerleader, they may be held to higher expectations that would apply to more than just their school days activities. And that's essentially been considered to be appropriate because participating in extracurricular activities is considered a privilege and not necessarily a fundamental right to the educational process. So the courts have been more lenient with upholding procedures which allow for the discipline of students for conduct that may not be as directly related to school. Drinking at a party if you're a high school student may be one example of conduct where that may be addressed through a code of conduct to participate in an extracurricular activity, but it may not be able to be addressed through the school's academic code of conduct or student handbook.
So that when you see a little cryptic remark that so-and-so could not participate on the football squad this week because of a violation of code of conduct, it doesn't mean they're suspended from school. It means that they did something that the football team isn't allowed to do. Is that right?
That's exactly right.
But it's still a school discipline.
That's right.
Yeah.
That's right.
Could it be both? Could there be situations in which they had violated both the code of conduct and the disciplinary code?
Yeah. Yes. And that would create an interesting situation regarding, from a legal standpoint, about the due process, because since it's not a right, it's a privilege. We know that the level of due process that they're entitled to is not quite as great, although schools have, because of the interest in sports and athletics, have been very careful in situations like that to still afford all the due process protections, typically in those kind of circumstances, because it's a community expectation.
And when a child in regular education is expelled from a school in Illinois, do they get any educational services during their period of expulsion?
The answer is it depends. Some school districts provide for alternative educational instruction for students who have been expelled from school. Illinois does not necessarily require that educational programs be provided to students who have been expelled from school, but many schools do, and there are many more opportunities over the past 10 to 15 years for alternative educational options for students, particularly since most students have access to electronic systems either in their homes, or there are programs set up that afford them an opportunity to be instructed, not on the side of their school building, someplace else during the term of the expulsion.
So that they could be expelled from the school, but
Correct.
not necessarily from education.
Correct.
But that's not mandated, right?
No.
But it might be something parents could ask for,
It might be something that parents can ask for.
Yep.
and hopefully they would be in a position to negotiate that for their child so they don't lose that time. This has been very, very helpful and very informative, and I thank you, all three of you, for coming on, talking about the disciplinary issues for students in our schools in Illinois. It's, I think, one of the topics that parents are most concerned about. This is one of those things where they should work with the schools
Absolutely.
and talk to their schools
Absolutely.
and obviously be informed about what the school rules are. Thank you to my three panelists. It's just been excellent. Thank you, Mary Klemish, John Dively, and Deb Decker. And we appreciate that you've spent your time with us watching Illinois Law, brought to you by the Illinois State Bar Association. I'm Nancy Hablitzel, and I hope you've enjoyed our program.